Well, hi, everybody. It's Gov Hutchinson from CAR. Maybe we'll give it another minute or so, see if anybody else wants to join us. When you have questions today, please just put them in the chat, okay? And I'll take them as they come. As you know, because you're here, this is a short review on the new RPA, organized, of course, by Shirley and the North San Diego County Association. It's recorded. Probably go for about an hour to an hour and a half. I have to be done by 2:30 at the latest. And by the way, I'm coming back. I'm probably gonna, I say probably because anything can happen, but I'm scheduled to come back in person June 29th in Escondido. Finally, they're going to start letting me go out into the real world. So I'm looking forward to that. So hopefully I'll see some of you guys then. Today, though, we are Zooming, of course. And all you have on the screen there, the only thing you're going to have is the contract itself, which I'm going to go over. Ferdane, if that's how you pronounce your name, yes, we'll definitely go over that. So obviously you've been using this form for a few months, and you may have taken a class on this form. Maybe you took more than one class, but it never hurts to hear. I really want to just go over the important changes that maybe you haven't noticed yet or picked up on yet, or maybe you have questions on, but sort of the important things that have changed. Not every little change, but the important things have changed on the contract on this version, okay? Now, big picture is, I've been doing this for 37 years, and 37 years ago, it was a 2-page contract. Then it went to a 4-page contract, a 6-page contract, an 8-page contract. Then it was a 10-page contract, and it's been a 10-page contract for quite a while. The forms committee sort of decided we should keep it at 10. But that's been about 15 years. In about 15 years, a lot of things have changed. There's new laws. There's new things that happen. The world has changed. And we've noticed some of the same issues come up time and time again. Some of the same questions come up time and time again. And they cause disputes. So the forms committee decided, what if we put everything in the contract that we've learned are sort of common questions that come up all the time? And if we can put it in the contract, then when it comes up, it's in the contract and you don't have to argue about it, right? That's sort of the thinking. So basically the form, you may have figured this out by now, it's not that it's that different than the 10-page form, even though it's now 16 pages. What it is just a lot of new explanations in the paragraphs you're already familiar with, just sort of anticipating problems and disputes and resolving questions. That's part of the explanation of why it's so much longer. The other part of the explanation is, of course, we have this new paragraph 3, what I call the grid, where all of the deadlines and negotiating points are all there in the same place. In other words, every place where the buyer and seller can negotiate something, like how much is it, what's the deadline, and who's paying. Those are all in the same place now. So you don't have to go looking for these things. You can't miss them. Sometimes you miss in the old form, you accidentally miss a blank or miss a term. Well, all the terms of the contract, the real terms, the important terms are all in the same place, which I think is helpful. Okay? All right. That being said, I'm just going to get going and go through this form. It'll take about a little more than an hour, maybe almost an hour and a half. I'm going to go through what's changed. And please put your questions in chat as I go. Don't wait till the end. As soon as you have a question, put it in there, okay? All right. Let's take it from the top. Paragraph 1, you're familiar with that. You know what the only thing that changed here is? All the years before it used to say the real property. Well, guess what? You know why it says the property now? Because we no longer have a mobile home purchase contract. So if you want to write an offer on a personal property mobile home, you use this form and the manufactured home addenda, which I'll talk about later. So in other words, this form is used to sell not just real property, but sometimes it can be used to do personal property. Okay, paragraph 2. You're all familiar with the agency form, very important, nothing's changed. The only change is, look at this sentence here. Buyer's agent's not legally required to give to the seller's agent the agency disclosure form signed by the buyer. Seller's agent's not legally obligated to give to the buyer's agent the AD form signed by the seller. Years and years, people ask the question, hey, I'm the listing agent, and the buyer's agent didn't give me their agency form that they gave their buyer. Or I'm the buyer's agent, and the listing agent won't give me the agency form they gave their seller. Well, you know what? They don't have to. So this is an example of that's always been true, but it wasn't in the contract. Now it's right in the contract. So if this question comes up, you just point to the contract. You see what the contract says? I don't have to give you the agency form I gave to my own client. Okay? All right. Then we get to the big paragraph 3. The all-important new, all the terms are in the same place. Everything you negotiate is in the same place. And you know what else I really like about it? In the grid, paragraph 3A through L are all the buyer's deadlines. And then M and N are the seller deadlines. So if you're wondering if you got a deadline you got to meet, you always look right here. All right. So what's changed in this paragraph? Well, the first thing, right away, when you put the price, you tell the seller right up front if you're making a cash offer. In the old form, you had to wait till you got to the financing paragraph. Now, right up front, cash offer. And remember, if you check this box by saying you're paying cash, you are removing one of the 8 contingencies. What is the first contingency? The loan contingency. By checking this box, you've removed it already. Okay? Close of escrow. You're familiar with this. You got to pick a number, or you got to pick a date. Now, there is one change that's real important in this contract, which is affected by this. All right, so how do you accept, what's the day of acceptance? Remember, the buyer signs the offer, the seller signs the acceptance, but we don't have a contract yet. The seller has to deliver the acceptance back to the buyer's agent. So remember, there's a 3-part process to create a contract. Somebody signs an offer or a counteroffer. The other side accepts the offer or counteroffer, and then they deliver it back to the other side. Well, the question is delivery. As a matter of fact, throughout escrow, you deliver things, right? Oh, I got so many days to deliver the disclosures, or I'm delivering a notice to perform. I'm delivering a contingency removal. I'm delivering a termite report. You always deliver things, right? And back in the day when I started, things used to be delivered in hard copy. But now we usually deliver things electronically, right? So I'm sending you a notice to perform. I'm sending you a contingency removal. I'm sending you an acceptance of the offer. Well, what constitutes delivery? Let's say I'm sending you an email. Let's say I email something and it's in your inbox, but you don't know what's in your inbox. Have you received it? Or I send you an email, it's in your inbox, you know it's there, but you don't open it. Have you received it? Or to receive an email, does that mean you actually have to open it? Do you know that's never been clear what the answer to that is? So for 30 years, I've been telling realtors, when you deliver something to the other side electronically, always follow up and make them acknowledge that they received it, right? We've been saying that forever. But you know something? I don't have to say that anymore. So I'm going to jump ahead here, but this is the only time I'm going to jump ahead today. I'm going to jump ahead to the definitions. Okay, paragraph 25. Acceptance. When the time the offer is fully executed and is delivered. Okay. So to accept an offer, you have to sign it and deliver it. What does delivery mean? Okay, let's see. Delivery of documents means that it's personally received by the other side of their agent. Well, that makes sense. If I send it to you, when you receive it, you've got it. But what does that mean? What does receipt mean? Look what it says here. There's two choices. Personal receipt could mean that the copy of the document is in the possession of the other party. So if I send it to you and you have it, you've received it. We have delivery. But what does it really mean to be in possession? We still don't know. So now there's a second definition, which is really good. Look at this. The other definition of personal receipt is an electronic copy of the document has been sent to the designated electronic delivery address specified in the broker section. In other words, delivery doesn't necessarily mean you received it. Delivery means I sent it. It's not my fault if you didn't get it. So here's the idea. On the last page of the contract, you, the agent, are filling this in. You're the buyer's agent or the seller's agent. There's a new section here where you put your designated email address. You could put a text number if you want. You can put more than one email. You can say, I only want this email, whatever it is. Let's say you put an email there and that's the only one you put. Let's say I'm the buyer's agent and I put an email there. And you're the listing agent and you put an email there. What I'm saying to you is, if you want to deliver something to me, all you got to do is send it to my email. You don't have to prove that I opened it. If you send it to the email I give you, and you can prove that you sent it, we have a deal. Or you want to send me a contingency removal notice to perform, send me a disclosure form. If you can prove that you sent it to the right place, you don't have to prove that I got it. Same thing, you put your email, that means if I send you something, as long as I send the email to the right place, as soon as I press send, it's considered received by you. I know what you're thinking, what if it goes into spam? Well, it's your responsibility to make sure my emails don't go into your spam. And I've got to make sure that your emails don't go to my spam. I've got to whitelist you to make sure it goes through. Well, what if you send me an email at 3 o'clock in the morning? Well, you know what? That means you received it at 3 o'clock in the morning. Yeah, but I was sleeping. Too bad. I sent it. You got it. No more argument about whether you opened the email or not. All I have to do is prove that I sent it. So to me, that's sort of almost the most important change in the whole form, if you look at it that way. All right. That's the only time I'm going to jump ahead. Okay, now I'm just going to go in order. Ferdinand, good question right up front. Talk about agency. If you're representing yourself, where do you say that? Well, I mean, it's going to be pretty obvious, right? I mean, if you're the buyer and you're also the agent, you're going to write down your name, right? So obviously that's telling the seller that you're both the buyer and the buyer's agent. I think that's what you mean, right? Okay. Terry Davis, is the email for delivery of documents filled in by the seller's agent when writing the offer? Well, when you're the buyer's agent, right, you write in the email address for you. Then it goes to the seller and the listing agent. And that's when the listing agent puts theirs in there. So in other words, you don't have to put in, you shouldn't put in the listing agent's designate. They're going to tell you in the acceptance what the email address they want you to use. Now I know what you're saying. Well, when I send the original offer, where do I send it? Well, send it to whatever email address you have on file. Maybe that's the right one for the future or not, but you don't know yet. But when they accept your offer or counter you, that's when they're going to put it in themselves. Okay. All right. Let's get back to paragraph 3. Okay. You know what else is interesting here? It says days. Remember, when a deadline says days, that means you count every day, but the last day has to be a business day. So if your offer is accepted today, day 0, then you count Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, Monday, you count every day, including Memorial Day. But if the 45th day falls on a weekend or a holiday, you go, acceptance is on the next business day, because that's what days mean. Well, how long is your offer good for? 3 calendar days. When it says calendar days, it means you count every day and you can end any day. So if you write an offer on Wednesday, that's day 0. The offer is good till 5 o'clock on Thursday, Friday, Saturday. Saturday's a deadline. It's a calendar day. What about your deposit? Well, you have 3 days to put, after acceptance, to put the deposit into escrow. But here it says business days. When it says business days, you don't even count Saturday and Sunday. So if you have an offer accepted on Friday, what's your deadline to open escrow? Wednesday, right? Because Friday's day 0. You don't count Saturday. You don't count Sunday, Monday, Tuesday, Wednesday. You know what else is new here? Look at this. Remember the old form for all your life? When you wrote an offer, the buyer could say, oh yeah, I'm going to do the deposit's going to be a cashier's check or a personal check or electronic funds. Now you have no choice. It's wire transfer. What if I want to do a check instead? Well, you can still check a box and write that in, but there's no checkbox to do it real easy. Presumption is you're always going to put the deposit in by wire transfer, okay? It also makes clear here that the important number is the dollar. Let's say you put 3% deposit, but then you calculate a number that's different than 3%. The legal number is the number, not the percentage. The percentage is not a contractual term, okay? What if you're going to do an increased deposit? You don't have to do an increased deposit, but if you do, at the time you do the increased deposit, you got to attach this addendum. It used to be called the RID. Now it's the DID. It's the same form. If I'm going to give you an increased deposit, when am I going to give an increased deposit? Well, now look, there's a new thing. It's presumed that if you are going to do an increased deposit, when you're going to do it, you're going to do it upon removal of contingencies. You can do it something different, but that's the presumption. That's the default. Loan amounts. Nothing has changed here other than it used to have another choice here. It used to say, well, it's going to be a conventional loan unless I check a box. There used to be a box for assumed financing. Lenders will never let you assume the seller's loan, so we took that out. Another thing, if you're FHA or VA, you check one of those boxes. If you check that box, these 2 forms attach. The FVAC, that's the one that tells everybody that if it's an FHA or VA buyer, even if you've removed your appraisal contingency, if it doesn't appraise, you get your money back. HID just tells you you should get a home inspection, required form. There used to be a 3rd form attached here called the FVA. Let's say you're an FHA buyer, VA buyer, and you want to tell the seller about lender required repairs. Well, look, you have to do it within 17 days. Well, it used to be we had a form to do that called the FVA. But then the forms committee said, we don't need that form. If you're going to request repairs, we already have a form for that called the RR, request for repairs. We don't need the FVA. Remember, this is the deadline to tell the seller, if you're an FHA or VA buyer, what the lender required repairs are. This is not the deadline to remove the loan contingency. This is a deadline to tell them about the repairs, okay? Another very small change. Let's say you want to make your offer contingent on getting a loan, and you want the loan that you're trying to get to have 0 points. On the old form, you had to write in 0. Here, it's presumed to be 0. You don't have to write up to 0. If it's 0, you just leave that blank. And here's one more new thing. Is the buyer going to buy this property as their primary residence, as a second home, or an investment property? It used to be you didn't find out till paragraph 9 which one it was. Now it's right up front because that's a negotiable item, right? All right. Second page. What about a seller credit? Sometimes you negotiate a credit right in the middle of escrow, but what if you want to ask for a seller credit right in your offer? On the old form, you had to put it here in additional financing terms. Now there's a special blank just for asking for a seller credit. So you have a nice little paragraph to do it. And the next question is, if I'm asking for a seller credit, you used to have to ask them, tell them what you want the credit for. So most people say they want it to be applied to closing costs. So it used to be you had to write that in. Seller to credit buyer X amount towards closing costs. Well, now you don't have to write that in. It's just check a box. You just check a box and write the number, and you've already asked for the credit, and you've made it clear that you're asking for it to be applied to closing costs. Okay? These three things I like. Remember in the old form, these three things are not right next to each other. I like that. I mean, if you're a cash buyer, you got to provide proof of funds. If you're a loan buyer, you got to provide proof of funds and a letter, a pre-qual or pre-approval letter. Well, now they're all right next to each other. That makes sense, right? They're very similar. And now they're all say the same thing. Remember how the old form for the loan buyer's proof of funds, it said it's presumed you have 3 days after acceptance to provide it, or if you check the box, it's attached. Well, now it's reversed, right? It's assumed, it's presumed that you always attach these things. If you're the cash buyer, you attach the proof of funds. If you're the loan buyer, you attach the proof of funds and you attach the letter. Remember the old form said, I'm gonna give you a pre-qualification or a pre-approval. It didn't say which one it was. Now you can check a box to tell the seller, hey, this letter that I've attached, it is a pre-qual, or it is a pre-approval, or there's a third option now. You've actually got loan approval, fully underwritten, just subject to the property itself. All right, the walkthrough, final verification. In the old form, you had to wait till paragraph 16 to find out how long when the buyer's walkthrough is going to happen. Now, since that's a deadline, that's a negotiable term, that's been moved up right into the grid. So now it basically says the same thing as it always used to say. Unless you say otherwise, the buyer's walkthrough is within the last 5 days. Here's a new thing. Is your offer assignable to another buyer? Yes, with the seller's consent. Okay. But the seller cannot deny their consent. They need a reason to say no. Well, this is brand new. Look at this. You now have a deadline to ask for an assignment. You can't just day before closing say, hey, seller, I want to assign my offer. In other words, if you want to assign your offer, ask for it within 17 days. What if I wait till after 17 days? The seller can just say no. They don't even have to have a reason. They just say no. Let's say you're thinking, well, I may need a co-signer on this offer, but I'm not going to find that out till towards the end of escrow. Well, then you might want to change this 5 to like 45 to give yourself the right to ask for an assignment. Remember, if you're going to add a co-signer, that's an assignment. You need the seller's permission. Okay. All right. Paragraph L. I think this is my favorite part of the whole new form. All of the 8 buyer contingencies are listed in the same place. For 30 years, I've been having to explain to realtors that there's 8 contingencies. Oh, really? Where are they? Then I got to tell them they used to be, there's some in paragraph 3, some in paragraph 4, some in paragraph 8, some in paragraph 10, paragraph 13. They're all over the place. Paragraph 12. No. All 8 contingencies are now in the same place. You can't miss them. You can't forget them. They're right there. Loan, appraisal, inspection, reviewing disclosures, prelim, HOA docs, solar lease, selling my property. So that's the first good thing. They're listed right there. Second, I love the fact they all have the same 17 days. Loan used to be 21. You can change these to whatever. These are all negotiable, but you're starting off with 17. Okay. What if I want to make a non-contingent offer because it's a competitive property and I want to make my offer look good? Okay, well, if you want to remove your loan contingency in your offer, you just check this box. If you want to remove the appraisal contingency, you check this box. What if I want to remove these other contingencies? You have to check this box and attach the contingency removal form. If you're just removing those two, you don't have to attach a contingency removal. But if you want to remove 3, 4, 5, 6, 7 in your offer, you need to attach that form. Well, what about the 8th contingency? Remember, the 8th contingency is kind of unique. This is the one where the buyer says, my offer is contingent on selling my house first. What's unique about this contingency is it's not automatic. The first 7 contingencies are always there. 8, if you want to make your offer contingent on your selling your house first, you have to check a box and you have to attach a form and you have to fill out that form. But once you fill out that form, you don't have to remove that contingency in 17 days. If I make an offer to you on May 1st, and I got all these contingencies, and I'm telling you, my offer is contingent on selling my house first, and my house is scheduled to close on May 30th. That means I don't have to remove this contingency until May 30th. I don't have to remove it in 17 days. In fact, you never have to remove this contingency. When we get to May 30th, either my house sells or it doesn't. If it doesn't, I can walk away. But you know what? If my offer is contingent on selling my house first and my house doesn't close on time, the seller can give the buyer, can give me a 2-day notice to perform. And then 2 days later, if I haven't sold, they can cancel the whole deal. Another interesting thing, the appraisal contingency used to be, you always said my offer is contingent on the property appraising at the purchase price. But now you have an or, you can write in a different number. Maybe the purchase price is $500,000. You could say my offer is contingent on the property appraising at $480,000. You can put a different number there. The appraisal contingency does not have to be based on the purchase price. Another thing to point out here, you got so many days to remove your inspection investigation contingency. But you know what? Regardless of that, you also have the right of access to the property. Maybe you only have 10 days to remove your investigation contingency. Maybe you only got 5 days. Maybe it's a non-contingent offer. You still, as a buyer, have 17 days to enter the property and access it. So you can look at it, examine it, measure it, whatever. 2 different things. Of course, a seller could counter you, I guess, and say, no, not only do you not have a contingency, we're not even going to let you look at the property. They could do that. It's all negotiable. Now, these first 3 contingencies, that's a hard deadline. There's never an extension of that deadline unless the seller wants to give you an extension. It's always 17 or whatever number you agree. But these 4 contingencies, the contingency is based on the buyer reviewing some documents that they received. And the buyer is not in control of ordering those documents, the seller is. Which means if the seller is late giving you these documents, they can't really expect you to remove the contingency in 17 days. If they're late giving, you always have 5 days after you receive the documents to remove the contingency, or 17 days, whichever comes last. What are the seller documents? That's everything the seller sends you. That could be all the disclosures, termite report, the previous buyer's inspection reports, all that stuff. Anything the seller gives you is a seller document. The prelim is something the seller orders. It comes from the title company. The HOA docs are something the seller orders that comes from the HOA. And the solar lease, if you got a property with a solar lease or a propane lease, that's ordered by the seller, but it comes from the solar leasing company. So if these things come in late, you have more time. Okay? All right. So those are all the buyer deadlines. Now we got the seller deadlines. The first big deadline for the seller, of course, is they got to move out. And the question is, when do they move out? First, you have to pick the time of day, then you have to pick what day it is. Time of possession. Well, the presumption is whenever it records, that's when the seller leaves. So if it records at 10 o'clock, records at 2 o'clock, that's when the seller leaves. But maybe you don't like that uncertainty. You want a hard deadline. Say, okay, the seller deadline is 6 o'clock. 6 o'clock. There's a good time. But the next question is 6 o'clock on what day? Well, then we go to the next line. Assuming this is a seller occupied or a vacant property, the move out day is COE, close of escrow. So if you check 6 o'clock here, that means the seller has to leave at close of escrow day at 6. What if the seller is going to stay beyond close? Well, you're going to check this box. They're going to stay up to 29 days. And then this SIP form now automatically attaches. It didn't used to automatically attach. This seller in possession is required now if the seller is going to stay beyond close for up to 29 days. What if the seller is going to stay beyond 30 or more days? Well, then this other form is going to attach residential lease after sale. These are now mandatory attachments if the seller is going to stay. Why would the buyer write in the offer that the seller is going to stay beyond closing? Because the listing agent put it in the MLS remarks, or they told the buyer's agent the seller wants a week. And since the buyer doesn't want the seller to counter their offer, they're going to write it in. Now, what if you're buying a house that's tenant occupied? Well, this is new. On the old form, in paragraph 9, you would talk about what happens to the tenant. But that's not in the contract anymore. To talk about the tenant, you have to use this addendum. So if you're buying a tenant-occupied property, even if the tenant's leaving, you always got to fill in this brand new addendum. Okay? In other words, is the tenant leaving a week before close, 2 weeks before close? Are they leaving on the closing date? Are they going to stay beyond the closing date? The answer is we have to look at this form. And what happens if the buyer's getting ready to close and the tenant's supposed to be gone and they're not there? And they're still there. What are the buyer's rights? Do they have the right to cancel? Do they have to close and keep the tenant? What's the deal? You talk about that in this addendum, okay? All right. What's the other seller deadline? Well, remember the seller has to deliver documents. They also have to order the prelim, order the HOA docs, order the solar lease. What is the deadline for those documents to go to the buyer? 7 days after acceptance. Maybe the seller should order these documents before you even put the house on the market to make sure you can deliver them within 7 days. In Northern California, in the Bay Area, I've noticed that a lot of sellers get all these documents together and they post them somewhere on a website and they say to the buyer, go look at these documents before you even write your offer, because it's going to be a non-contingent offer, right? I skipped 2 for a second. Here's another seller deadline. Not only do you have to make sure the buyer gets the HOA docs in 7 days, you got to make sure you pay for them within 3 days. Of course, the HOA isn't going to do it probably in 7 days. You might want to take care of this before you even sell the house. Here's a new deadline. Every seller on residential must put in smoke alarms, carbon monoxide detectors, and strap the water heater. They've got a deadline to do that 7 days. Remember the old form, the deadline was close of escrow. Now the deadline is 7 days. So those are the seller deadlines. Then N3 and N5 are buyer and seller deadlines. Whether you're the buyer or the seller, when the escrow company sends escrow instructions, you got to return them within 5 days. If you don't, you're in breach of contract. If I'm the buyer and I don't return my escrow instructions on time, the seller can give me a notice to buyer to perform to do it. Or if I'm the buyer and the seller doesn't, I can give them a notice to perform. The other deadline that's both a buyer and seller deadline, let's say the buyer or the seller is not a person, it's a thing. Trust, corporation, partnership, LLC. Somebody has to sign on behalf of that entity. Who's ever signing has 3 days after acceptance to deliver to the other side the proof. Let's say I'm the buyer and the buyer's a trust. I got to send him the trust document that shows I'm the trustee. Let's say the buyer's a corporation and I'm signing as the president. Within 3 days, I got to send to the other side the corporate document like the articles of incorporation or bylaws that says I have the right to sign. I'm the president. Okay? All right. Still in the grid here, paragraph P. Now, you know when you sell a house, right? Everything that's built into the house or attached to the house or there's a special opening, that's part of the house, stays with the house. But if it's not attached, there's no special opening, then it belongs to the seller. The problem is, with a lot of items, it's not crystal clear whether it is built in or not, or whether it's a special opening or not. And you don't want the buyer and seller to argue about it. So we'll make it simple. These are the things that people tend to argue about. Stove, refrigerator, wine cooler, washer, dryer, dishwasher, microwave, video doorbell, security equipment, jacuzzi, mirrors in the bathroom, Tesla charging station, all that stuff. Well, the question is, buyer, if you want that stuff, just check the box. If there's any possibility in your mind that someone could argue that it's not really built in or attached, just check the box. If the seller doesn't counter you, that means you've both agreed that it's part of the house. By the way, the forms committee thinks the bathroom mirror should always be included, so they pre-check the box. What if there's something that you want that's not listed here? Add it in. What about excluded? What if there's something you don't want? What if the seller has this big old refrigerator? You don't want it. You want it. You don't want, even though it's sort of built in, you definitely don't want it. So you exclude it. Or maybe there's a chandelier in the dining room. Light fixtures are part of the house. But the buyer says, I don't want that light fixture. I want them to take it away. So you can specifically exclude it. You can't rely on what the MLS says. MLS says refrigerator included. You still have to check the box, right? MLS says jacuzzi included. You still got to check the box. The MLS is not part of the contract, same as the flyer, okay? Now, what about paragraph Q? This is the paragraph. Oh, by the way, let me look at the questions. Charisse asking me a question. I thought it was important to determine, to state right in the contract whether it was recurring or non-recurring closing costs. I guess if you want to break it down that way, so you're asking the seller not to, you don't want the credit just for all closing costs, it's only for non-recurring closing costs. You could write that in, you're right. Ferdane, if the purchase price includes the agent's commission, where can we say that? Well, I mean, you don't really have to say that, unless it depends on what you're trying to do here. You're trying to say that the buyer's agent isn't getting a commission. Well, you don't have to tell the seller that. I mean, if you want to tell the seller that and they're wondering why is, or you're telling the seller, are you trying to tell the listing agent that they don't have to pay you, the buyer's agent, the commission? Are you waiving your commission? You can do that, but you don't do that in the purchase contract. You could do that directly between the buyer's agent and the listing agent. And then you would probably put an addendum. You'd probably mention it on an addendum, basically saying to the seller, my offer is actually better than it looks like because your agent doesn't have to pay my agent a commission, which means, of course, the seller's going to go to the listing agent and say, well, if you don't have to pay the buyer's agent a commission, I'm going to pay you less of a commission. Because just because the listing agent isn't paying the buyer's agent doesn't mean the overall commission goes down, right? Anyway, quick answer to your question, put it on an addenda. Charlene, how do you know what the closing costs are? Well, you estimate. That's all you can do. Terry, yeah, I think I already addressed. If seller says items are excluded in the MLS, I mean, if I'm a smart buyer, my agent tells me that, and since I don't want a counter offer, I just exclude it in the offer, or you can just wait for a counter. It's up to you. All right. Anyway, paragraph 3Q. This just used to be paragraph 7. The idea is this. There are fees that have to get paid when you buy a house. The question is, who's going to pay them? The buyer, the seller, or some combination? The only thing new here is that now there's a box for both on everything. What if you check both? That means buyer and seller each pays 50%. What if you want the buyer to pay 40% and the seller to pay 60%? Well, you check both and then you write it in, buyer 40, seller 60. If you don't write anything in, it's assumed it's 50-50. For the escrow fee, there's a fourth choice. Buyer pays, seller pays, both. Each pays their own. You see, sometimes in escrows, there's one escrow fee. But then in addition to the big escrow fee, there are other specific fees. There's sort of buyer fees or seller fees. So the point is you might want to check both, which means they split the overall fee, but then the specific additional fees, each pays the one relevant to them. Okay. By the way, when you're writing in the Q1, 2, and 3, you know, the buyers may want to get a termite report, roof report, lead report, radon report, and they're going to pay for it themselves. Buyer, if you're going to order a report, but you're going to pay for it yourself, you don't really have to write it in. Little tip is only write in things that you're going to ask the seller to pay for, or both of them. Pretty much everyone agrees that the seller should pay for the NHD. That's really the only one that everyone agrees seller should pay for. Usually most other reports that are gotten, the buyer pays for. You can ask the seller, but you don't have to list all the ones that the buyer is planning to pay for. Okay. What about these? Remember, sellers have to put in smoke alarms, and if you're in LA or something, you got to do a 9A report. Some cities require you to do point of sale upgrades. LA example, for example, has point of sale plumbing upgrades. I don't know in northern San Diego County whether you have any cities that require government inspections or government upgrades. But I know you always have smoke alarms. So the point is, if the seller is going to pay for it, fine. But what if the buyer is the one who's going to pay for it? Well, that means the seller still has to do it, but the buyer can agree to pay the money. What if the buyer agrees to pay for the smoke alarms, but but they don't give you the money, and now it's time to put in the smoke alarms? Seller, you still got to put them in. The buyer owes you money. You can sue the buyer for the money, but just because the buyer said they're going to pay for it and they don't pay for it doesn't relieve you, the seller, of the obligation of doing these three things. These are requirements that have to be done by the seller. You can negotiate who pays for it. Okay. Another change. Let's say you're buying something that's in an HOA, right? And the HOA is going to give you several documents: articles, bylaws, budget, reserve study, CC&Rs. Those are called the required disclosures. And then there are the optional disclosures. You know what those are. Is there pending litigation, 12 months of minutes, rules and regulations, pet fees, smoking rules, pet rules. In the old form, it said seller always pays for the mandatory ones, but you negotiate the optional ones. That caused such confusion. The Forms Committee said, let's just make it simple. Seller pays all of the fees to the HOA for the documents, whether they're the required by law ones or the other ones, because the buyer wants them all anyway. Okay, all right. A little change here, transfer fees. Some HOAs, they have a transfer fee, but then they have, in addition to that, they have a specific buyer move-in fee and a seller move-out fee. What this is saying is, regardless who pays for the big fee, buyer, seller, or both, if there's a move-out fee, seller pays. If there's a move-in fee, buyer always pays. Okay? All right. Other terms, paragraph 6 on the old form. Now it's other terms. There's not a whole lot of blank lines here. But you know what? If you start typing in these blank lines and you run out of room, it automatically expands. Or just use an addendum. All right. Back to the chat real quick. Charlene, can you define affixed items? In other words, garage cabinets, for example, they were placed in remodel and they're not hanging or attached to the wall. That's a great question, Charlene. And that's why we have paragraph 3P. 3P would be, is where you check a box and you'd write, you know, cabinets. So even though it's not really attached, but they used to be attached, so they're considered attached or not, rather than argue about it, that's the exact reason why we have 3P. Something like that, where it's sort of a gray area, you just check the box and you write, cabinets sitting in the garage belong to the house or something. They're included. Okay. Otherwise, you're right. It's not clear. All right. No more grid, no more negotiation, no more deadlines, no more numbers. The rest of the form is just information. There's some decisions that have to be made, but not much. First of all, paragraph 4 used to be paragraph 5. This is where you attach an addendum. There are 5 new addenda. That's what A is. No more probate purchase contract. If you're going to buy a probate, you use this form and check the box, attach the addendum. No more mobile home manufactured home purchase contract. If you're buying a personal property mobile, use this form, check the box, attach the addendum. I already told you, if you're buying a house with a tenant on it, you need this form to deal with the tenant. Another new form is, there's some properties in this state where you're not actually paying a deed for a fee simple interest. You're actually just getting a share in a tenant in common interest. If that's you, use this form and use this addendum. And some properties in the state are now owned in the form of a co-op. You're joining a co-op. If that's you, use this purchase contract, check the box and add that. These are the old addendas, and these are the advisories. Remember, an addendum is different than an advisory. An addendum has to be signed by both sides. It's part of the contract. An advisory is really just advice. Typically, it's advice from the buyer's agent to the buyer. You don't give advice to the seller. You do not need your seller's signature on these forms. The forms committee said these 4 forms are so important, we're going to force you to give them to your seller. Inspection, wire fraud, fair housing, privacy. These other ones are good forms. If I were you, I'd probably always give my buyer the wildfire advisory and the statewide buyer. You don't have to. If it's a trust sale, I'd probably give them the trust advisory, REO advisory, short sale, probate. What if I'm the listing agent and I want to give these forms to my seller? Knock yourself out. You can give it to your seller separate from this form, or you can check this box in a counteroffer if you want. I mean, either way, this form is going to go to both sides. But as an agent, you do not need the other side to sign the advisory. The advisory is to protect you with your own client. If I'm the buyer's agent giving the fair housing advisory to the buyer, I don't need the seller's signature. And the listing agent already probably gave it to them as part of the listing. Whether they did or not, you don't care. Advisories are advice to your own client. The only new one here is the wildfire disaster advisory. Don't confuse that with the fire hardening defensible space form. That's a mandatory form. This is just an optional advisory. All right, paragraph 5 and 6 used to be in paragraph 3. Remember, paragraph 3 is all the loan stuff. It's now mainly in the grid in paragraph 3, but there's still a couple of issues to be addressed. This is just information. What's changed here? A couple of things. This is very important. Look at C3. The buyer is authorizing the seller and the seller's agent to contact your own lender to determine the status of the loan. In other words, you are telling the other side they can contact your lender, not for confidential information about the buyer, just to find out if the loan, if it's been approved or not. And you have to give them give the seller and the listing agent your lender's contact information within 1 day. So that's a new thing. Here's another new thing. Remember I said that if you're the buyer's agent or the buyer, and it's an FHA buyer, right? You have 17 days to notify the seller what the lender required repairs are, right? You know that? Well, look what it says here. If FHA or VA is checked, those forms are incorporated, and buyer shall, within the 17 days, deliver to seller written notice of any lender requirements that you want the seller to pay for, or that there are no lender requirements. So in the old form, you only had to tell the seller if there were lender requirements. Now, you got to tell this, if you're an FHA or VA buyer, you got to tell the seller if there are no lender requirements or there are lender requirements. If there are, there used to be a form called the FVA. Now you don't need that. The form's gone. You just use the simple request for repair. What if you're an FHA buyer and there are no lender repair requirements, no lender requirements? Well, then you're going to tell the seller that, use this form, the amendment form, the amendment to existing agreement. Okay? Nothing else really changed in this paragraph. Paragraph 7 used to be paragraph 9 and paragraph 11. 9 deals with possession, 11 deals with as is. So first of all, this reminds you that this is an as is sale. What does that mean? That means the seller doesn't have to fix anything other than, smoke alarms, carbon monoxide detectors, and any local government repairs. But the property must be as is on the day of acceptance. So if anything is working on the day of acceptance, like the dishwasher, for example, and then it breaks down in the middle of escrow, seller has to fix it because it was as is as of the date of acceptance. Have you ever had this happen to you? Dishwasher's working, all through escrow, it continues to work. Then the seller closes and then the seller rents back. So now the seller's a tenant for a couple weeks. Halfway through that tenancy, the dishwasher breaks. Who has to fix it? It's still the seller. Even though they're now a tenant, they don't own the property. They said it would be delivered as is. In other words, when the time possession is delivered to the buyer. Okay? Here's another new thing which I really like. Have you ever had a closed escrow where the sellers leave some of their crap behind? Sometimes it's junk, sometimes it's perfectly good table or something, but buyer doesn't know what to do with it. What are their rights? And it was never really clear in the contract. Now look, it's very clear. Okay, all debris and personal property shall be removed at the time possession is delivered. If items are not removed when possession is delivered, all items are deemed abandoned. So if I'm the buyer and the seller leaves stuff behind, I can assume that it's mine or it's trash I can get rid of. I do have to give them 3 days notice. Dear seller, you left some stuff behind, you got 3 days to get it. How do I know how to contact the seller? You send it to their agent, or you just write a letter to the address that you just bought. 3 days you haven't heard from them, buyer, you can do whatever you want. Remove it, dispose of it, keep it, and you can even sue the seller for the cost of removing it. So this is very much more pro-buyer than it used to be, okay? Nothing else has really changed here. Paragraph, remember, I said my favorite part of the form was paragraph 3L. It has all 8 contingencies. Well, paragraph 8 just has a few explanations. Okay. Nothing, there are a couple of new things here. Paragraph 8A2 reminds buyers that in this environment now, you should investigate the insurability of the property as early as possible. Remember, traditionally, you removed your contingencies and then right before closing, you checked out how much insurance was. Insurance can be so expensive now and so hard to get that you probably want to check it out before you remove your investigation contingency. So if you can't get insurance, that justifies you to cancel based on the investigation contingency. So that's a new thing. Okay. Here's another new thing. You know how you get an appraisal, your offer is contingent on getting an appraisal. So the appraiser comes back and tells you whether it appraises or not. But on the appraisal, the appraiser often also tells you what they think the square footage is. Appraisals are often a reliable source. So what if you thought the square footage was 3,000, the appraiser thinks it's 2,500? Can you cancel the deal based on that? Well, if you still have your inspection contingency, yes. So the ability to cancel based on the measurements provided in the appraisal is within the investigation contingency. If you've removed your investigation contingency, but you still have the appraisal contingency, and it comes back and says, yes, the property appraises, and I think the square footage is X, the buyer cannot use that as a basis to cancel. So you can only use the investigation or property contingency to cancel based on the square footage opinion of the appraiser. Okay. So anyways, that gives you little comments on the loan contingency and the appraisal contingency and the inspection contingency, review of documents, the prelim. This is slightly different. You know, for years, your offer is contingent on approving the prelim. Well, now look what it says. The prelim contingency means the agreement is contingent on buyer's ability to obtain the title policy in the paragraph and reviewing the prelim. When we get to paragraph 13, you'll see paragraph 13 says the buyer gets a specific type of title insurance. What if the buyer, the title company won't give the buyer the title insurance policy in paragraph 13? Well, the buyer can say, well, I'm canceling the deal because my offer was contingent on getting that specific title policy. Here's another new thing. Have you ever had this happen to you where title company does an original prelim, buyer's okay with it, removes contingency, and then middle of escrow, for some reason, the title company issues a revised prelim? Well, look what it says here. Buyer, you have a brand new contingency. You have an extra 5 days to review it and cancel if you don't like it. This is only though if the prelim is materially different than the original. Okay. Remember, one of your contingencies is reviewing leased items, solar lease, for example. So I'm buying a house, seller tells me, I don't own those solar panels, they're leased. So I want you to assume the lease. Well, the seller has to send the lease to the buyer, and then the buyer has the right to review it. Okay, that makes sense. So buyer's review release is okay. What if this lease company says, okay, buyer, you can assume the lease, but the seller has to pay an assignment clause or something like that? Seller can say no. Look what it says. Any assumption of the lease shall not require any financial obligation or contribution by the seller. In that scenario, the seller can say, I'm not paying it. Buyer, you pay for it or forget it. The deal's off. The other thing it says here is, okay, so let's say the buyer reviews the prelim, the solar lease. They're okay with it. The solar company says, okay, you are authorized to assume the solar lease. Great. but the buyer, you still have a deadline to sign the contract to accept the assignment. In other words, it's not just you have to tell the seller within 17 days, yes, I will assume the lease. You actually have to sign the documents actually assuming the solar lease within the 17 days, or the seller can give you notice to perform. Okay? All right. I think that's all we really need to say about the contingencies. Nothing else has really changed. Paragraph 9 used to be paragraph 8. This works together with 3P. Remember, paragraph 9 is basically saying, in general, everything attached to the property stays with the property. It's included. Also, all fixtures, ceiling fans, fireplace inserts, built-in appliances, and appliances for which special openings or encasements have been made. These are the debatable things where the buyer says, yeah, that's built in. The seller says, I don't think it is. That's why you check the box in 3P. But what if it's 100% guaranteed, clearly built in? Nobody in their right mind could say that that's not built in. Well, in that case, you really don't have to check the box in 3P. I mean, if it's 100% no possibility of argument, then you don't have to check these boxes. To be safe, though, if I'm a buyer, I'm going to check all these boxes. All these things that I want, I'm not going to rely on the fact that it looks like it's pretty clearly built in. I'm just going to check the box. Why not? Now, what I like about this is that they've defined some things. You know how window coverings are included? Well, now it definitely says that blinds, curtains, drapes, shutters are window coverings. Or at pool equipment, spa equipment's included. Well, now it specifically says that includes motorized pool cleaners, nets, and covers. Are light bulbs included? Yes, light bulbs are now included. Security systems included. What does that mean, the security system? It explains it. Smart home features are included. It explains it. All right, so there's just more explanation of what is included and what's not. Okay. Remind you that at close of escrow, seller, you got to work with the buyer to help them figure out what apps are needed to use all of these smart home features. Remember how the flat screen TV is not included in the sale unless the TV itself is attached, but the TV is never attached. There's always a bracket attached to the wall, and then the TV's attached to the bracket. And just like the old form, it says the TV and the speakers are not included in the sale. Well, what about the bracket? On the old form, there was a checkbox to determine whether the bracket was included. Now the presumption is the seller is going to remove the bracket. So unless otherwise specified back in 3P, brackets will be removed and damage repaired. Okay, it's a presumption now. Paragraph 10, you remember back in 3Q, we talked about who's paying for what. So what's the purpose of paragraph 10? Just to explain a couple things. One thing that's explained that was never explained before is if it's something that's legally required, but the buyer's going to pay for it, how does that work? Well, buyer, you're going to work with escrow to deposit funds directly into escrow or directly to the vendor. What about mandatory local point of sale requirements? Same thing. First of all repairs, right, are going to be done. I mean, smoke detector water, that's got to be done within 7 days. What about point of sale inspections or any other repairs that the seller agrees to do? When do they have to be done? Prior to walkthrough, prior to final verification. What if the buyer is going to pay for it? They're going to directly pay the vendor or provide an invoice to escrow. What if the seller doesn't do the repairs on time? And this results in the lender on time means before the walkthrough. And the seller being late doing the repairs results in a reinspection fee from the lender and maybe some other costs. Well, this was never in the contract before, but now it says, if a repair is not completed within the time specified, seller shall be responsible for the reinspection fee and any other costs. I mean, it's their fault. They were late. They should pay any resulting cost to the buyer. Okay. All right. Paragraph 11 used to be 10. This is the disclosure paragraph. Very important. Is there anything new? It's just sort of been a couple words have been changed around to try to make it a little more easy to understand. Let me give you my take on it. When it comes to disclosures, everything in paragraph 11 is required by law. You can't waive it. But you know, there are big disclosures and little disclosures. There are 5 big disclosures. What's the difference between a big disclosure and a little disclosure? A big disclosure gives the buyer a 5-day right to cancel. So even if they've removed their contingencies, if you're late giving them one of the big 5 disclosures, they still have 5 days to cancel. I mean, if you give them to them right away, those 5 days are gone before the contingencies are gone, so they have more time. And did you know if you give the big 5 disclosures to the buyer before they actually even write their offer, they don't even have a 5-day right to cancel. What are the big 5 disclosures? Well, the first one is the TDS. Second one is the NHD report. And the third one is other statutory disclosures. There's a whole bunch of them, but we put them all together on the same form called the Seller Property Questionnaire. So most of your deals, you got to do a TDS, NHD, and SPQ. Those are the first 3. But if it's a probate sale, REO sale, bankruptcy sale, or a trust sale, where the trustee has never been on title or lived there in the last 12 months, those are exempt from the TDS. If you're exempt from the TDS, you're also exempt from the SPQ, but there's a different form, the exempt seller disclosure. So most sales, you have TDS, NHD, SPQ. Probate, REO, bankruptcy, trust, you have NHD and ESD. No TDS, no SPQ. Okay? By the way, here's an interesting question that comes up a lot. You have to read this. When is a TDS considered complete? Answer: when the seller has checked the box in section 1, answered the questions in section 2, and the seller's agent has signed their part or delivered an avid. You notice the buyer's agent's avid is not required for the TDS to be complete. So if I'm the listing agent, my seller has signed the TDS, I've signed my avid, I give it to the buyer's agent, that starts the 5-day right to cancel. Yeah, but the buyer's agent hasn't done their avid yet. Too bad. That's a bad buyer's agent. Because now, even when you finally do your avid, even if you find a problem, the buyer can't do anything about it. So as a buyer's agent, you should always do your avid early. So when the listing agent gives you their TDS and their avid, you give the whole thing to the buyer so they can get all the information at once, and they got 5 days. Here's another thing that's explained. What if you're in the middle of escrow, the 5 days are gone, the contingencies are gone, and something new that's important comes up, some material fact. If the seller or the seller's agent becomes aware of something or realizes they made a mistake, they have to give an amended TDS, SPQ, or other document. Doesn't matter whether you use a TDS, an SPQ, or just a blank piece of paper. If the seller or the listing agent gives new important information to the buyer's agent after removing contingencies, after the 5 days, that's considered an amended TDS, and the buyer has a new 5-day right decision. But what if the buyer or the buyer's agent is the one that discovers the problem in the middle of escrow? Seller honestly didn't know about it. Listing agent honestly didn't know about it, but you just discovered it. Can you get out of the deal? No. A subsequent or amended disclosure shall not be required for conditions or material inaccuracies of which buyer is aware or which are discovered by buyer or disclosed in reports provided to by the buyer. So moral of the story is, buyer, you better investigate everything you're interested in and have your agent investigate everything before you remove your contingencies. Because once you've removed them and you've already passed your 5-day right of rescission, just if something new comes up that you figure out, you can't cancel based on that. All right. What's the fourth big disclosure? Lead disclosures, only if the property is built before 78. Remember, the lead disclosures means two things. There's a form on zip form, the LPD, and then there's a pamphlet, the lead booklet under the electronic publications library of zip form. You got to give them both to the buyer if it's pre-78. The fifth big disclosure is the new one that happened last year, the fire hardening defensible space. Only required if the house is in a very high or high fire zone as determined by the NHD report. And by the way, it's only required, this form is if a TDS is required. Probate, REO, bankruptcy, or trust sale, even if you're in a high or very high fire zone, this form is not required. Okay, those are the big five. Did you know that not only do these give the buyer a 5-day right of rescission, even after those 5 days are gone, buyer has to sign and return them. What's your deadline to do that? Either 17 days or 5 days after you got it. If you don't sign and return the big 5 disclosures, the seller can give you a notice to perform. 2 days later, they can cancel you. In other words, even though the 5-day right of rescission might be gone, you still have to return. Now, what are the other disclosures, the small ones? Well, there's the FERPTA form, qualified substitute, and there's the HOA disclosures, earthquake guide, environmental hazards booklet. These are all required disclosures, but they don't give the buyer a 5-day right to rescind. Of course, buyer, remember, you have a contingency for seller documents. And all these disclosures are part of seller documents. And you don't have to remove the contingency until at least 5 days after receiving them. So if the seller's late giving you the earthquake guide, environmental hazards booklet, they're late giving you the HOA docs, you can still, you don't have to remove your contingencies until you get them. By the way, one more thing. The Megan's Law, I'm sorry, the FERPTA form, the qualified substitute form, that is only, that is not required to be delivered to the buyer until the close of escrow. So that's the one where there's no real other deadline. Okay, all right. Before we go on, okay, we're just talking about the recording. Terry Davis, great question. No, the fire hardening defensible space form is not added automatically. Listing agent, you have to figure out whether your listing is a TDS transaction and it's in a high or very high fire zone. How do I know if it's in one of those zones? You look at your NHD report. There are 2 boxes on the NHD for fire. One says very high fire, one says wildland area. If neither box is checked, you're not in a fire zone. If very high is checked, you're in a very high, you need the form. If wildland is checked, you're either in a moderate or a high fire zone. How do I know which one? Ask your NHD provider, they can tell you. If it's high, you need the FHDS. If it's moderate, you don't. Paragraph 12, nothing has really changed. It's just like paragraph 12 in the old form. The only little change is, are you allowed to damage the property while inspecting it? No. There's always been an exception for minimally invasive testing required for a termite report, like drilling holes. But now this clarifies that if it's stucco, even the termite guy is not allowed to drill any holes in stucco without the seller's written permission. Is the seller required to move their furniture for the inspection? No, seller's not obligated. Is the buyer required to give a copy to the seller of all their inspections? Yes. Does that include the appraisal report? No, unless it's an FHA or VA. Right? So look what it says here. This delivery of investigation reports does not include any appraisal unless it's FHA or VA. Another question that came up time and time again. Now it's in the contract. Paragraph 13, I told you about this. What's changed here? Well, what's changed, one thing is, okay, what type of title policy does the buyer get? Well, it's presumed you're going to get the ALTA, CLTA homeowner's policy. If applicable to this property. Some properties, the title company will not offer that policy. On the old form, if the title company wouldn't offer that policy, all the paragraph said is go talk to the title company about what policy you want. Now, no, there's a second choice. If this one's not available, buyer gets a CLTA standard. Usually that's always available. But what if for some reason neither one of these policies are available? Remember, the contingency here is your offer is contingent on getting the policy described in paragraph 13. So if for some reason you're the buyer and the seller won't give you, the title company won't give you either one of those policies, you can back out of the deal. Here's a new thing. Paragraph E, buyer's an entity paying $300,000 without a bank loan. In other words, you got an all cash buyer paying at least $300,000. There's a federal law that says in that scenario, the title company has to tell the federal Treasury Department who the real people are hiding behind the entity. See, the federal government thinks that criminals are laundering their cash by buying residential property for all cash without revealing their real names. So there's a new law now that says if that's who the buyer is, the title company has to tell the Department of Treasury who the real buyers are. By the way, if you have a buyer who reads this and says, you mean I got to tell the federal government who I really am? And then they say, I don't want to buy the house anymore. They just told you that they're probably a criminal. By the way, this law applies in San Diego County. This law applies in LA County. This law does not apply in Orange County. If for some reason you're doing a deal in Orange County, all cash entity, this paragraph doesn't apply. Apparently there are no drug dealers in Orange County. Paragraph 14, very important paragraph. Nothing has really changed here. The only thing, it's been sort of restructured a little bit. I really like it. It has all in one place. When can a seller cancel? And then right after that, when can a buyer cancel? So if your client is wondering, well, something just happened, do I have the right to cancel? You can always look here. If you're the seller, buyer didn't remove their contingencies, you can cancel. Buyer missed any of these deadlines, almost all of them are in paragraph 3, you can cancel. Seller had a contingency in their acceptance, like they accept your offer contingent on finding a replacement property and they haven't found it yet and they haven't removed the contingency, you can cancel. When can a buyer cancel? Well, if there are seller contingencies, they haven't removed them, or the seller missed any of their deadlines back in paragraph 3N, or of course, if I still have a contingency, I can use that as a basis to cancel, assuming I'm acting in good faith. So it just sort of gives a nicer explanation, I think. I like that. All right. This makes it clear that when you give someone a 2-day notice to perform, you have to give them at least 2 days. You can't just give them a 1 day or half a day. You can give them more than 2 days, but you got to give them at least 2 days. Okay. Same thing if you're trying to cancel a buyer or seller because they didn't close on time. Remember, if someone misses a deadline in the contract, notice to perform, wait 2 days, cancel. But you got to give the money back to the buyer. But if you don't close on time, you can give the other side 3 days to close, demand to close, not notice to perform. And then got to give them at least 3 days or more. But then if you give someone a demand to close, you give the buyer a demand to close and they don't close. Now, if they've removed their contingencies, you have the right to go after their deposit. It talks about all that. Paragraph 15, repairs. Nothing's changed. Walk through. Nothing's changed. Prorations, a couple of changes. Proration is basically saying all the financial obligations that come due in the middle of the month, you prorate it. So if you close on the 10th, any financial obligation that comes due that month, whether it's before the 10th or after the 10th, the seller would pay the buyer would pay a third of it, the seller would pay 2/3. But now there's some exceptions. Look at this. Special HOA special or emergency assessments are not assessed. Are not prorated. In other words, for example, you're closing escrow on the 14th. Special assessment is due on the 13th. The seller has to pay the whole thing. Closing on the 14th, the special assessment is due on the 15th. Buyer pays the whole thing. No proration. Same thing for service bills and utility bills. Paragraph 18, no change. Paragraph 19, they change a word or two here and there. Nothing significant. There's some good things, like the escrow company said, could you please put something in the contract that says, if we ask for invoices, they'll give it to us. Yeah, so you got to give 3 days. If they ask for an invoice, give it to them, right? And here's another thing. If the escrow company asks you to sign additional instructions to make the deal close, you have to cooperate with escrow within 3 days. And also, if you do an amendment, you got to give a copy to the escrow within 3 days. So these are a bunch of deadlines, 3-day deadlines. They are not, they're sort of mentioned in paragraph 3, 3 and 2, that you got to do it. Remember 3 and 2, you got to return escrow instructions, the original escrow instructions within 5 days. Well, this is saying sort of for extra stuff or invoices or amendments, you got to give those to escrow within 3 days. And if you don't, you're in breach of contract. The other side can give you a notice to perform and cancel. Nothing changed in 2021 MLS. There's a new thing here, starting here. Sometimes buyers close escrow and they say to the MLS, they say to the seller, they say to the listing agent, I want all those pictures of the property taken off the MLS. I don't want them off the MLS. I don't want them on the internet anymore. This explains to your client, to the buyer, first of all, by California law, the MLS cannot remove those images. And anything that's on the internet, they couldn't remove that even if they wanted to, nor could the seller or the agents. 21, no change. 23, the assignment paragraph has been beefed up. Look what it says. First of all, buyer, if you want to assign your interest to your own trust or your own wholly owned entity, you can just do it. No problem, anytime you want. Otherwise, you can't assign without getting the seller's consent. Seller can't be unreasonable. Buyer must tell the seller who the assignee is. Buyer must tell the seller how much money the assignee is giving the buyer. By the way, if it turns out that the assignee is someone the seller knows who they don't like, that's a reasonable basis not to agree to it. Or if they find out that the assignee is paying a lot of money to the buyer, you got to tell the seller said that's too much money, I don't approve it. Buyer must give the assignee all documents. But if the assignee is a trust or wholly owned entity, the assignee doesn't have to re-sign anything. Here's another brand new thing. All assignees must provide a pre-qualification letter from their lender to the seller within 3 days. Otherwise, the seller can give the assignee a notice to perform and cancel the whole deal if they don't do it. And of course, as I told you before, back in 3K, it says buyer has 17 days to request an assignment, unless you change that number. If the buyer requests any assignment after that time, seller can simply say no, they don't have to be reasonable. 24, don't discriminate. 25, I told you about the only important definition change. That's the definition of delivery means personal receipt, and personal receipt now means you don't have to prove that they received it. You just got to prove that you sent it. It also says here, by the way, if you send something, instead of sending the document, you send a link to the document. The recipient can say, I don't want a link, I want the actual document. It says if the recipient of the link is unable or unwilling to open the link, or they prefer delivery of documents, they can tell the sender within 3 days, and then they have to resend it. Okay, 26, 27 haven't changed. 28, they used to say representative capacity, signature, disclosure. We don't need that form anymore. If you're signing on behalf of an entity, you're a legally authorized signer. You're going to sign it that way. What you're saying here is, this entity that I represent does exist, is in good standing, and as I mentioned before back in the grid, you got 3 days to send to the other side proof that you have the authority. Liquidated damages, no change. Mediation, no change. Arbitration, there's now a blank here. Let's say you're the buyer's agent, you want arbitration. You can actually put in the name of the arbitrator or the arbitration company that you want. Seller may not like that. So I guess this is a negotiable item that's not in paragraph 3. Okay, that may or may not come up. And remember, of course, if you're fighting over 10,000 or less, you don't have to mediate or arbitrate. Also remember, these are optional paragraphs. Your clients don't have to initial them. But let's say the buyer wants liquidated damages, the seller doesn't, or vice versa. You don't have a binding contract until they agree. Okay, they have to agree. If they don't agree, don't open escrow. You got to keep negotiating until either they both initial it or neither one initials it. Same thing with arbitration. We're finally at the signature page. What if the buyer's an entity? It's not a person. You check this box and you put the name of the legally authorized signer. You don't need the RCSD. By the way, if the trust has a really long name and you couldn't fit that on the first page, here's where you put the full trust name. And the buyer signs it, right? If it's a person, you print their name. If it's a legally authorized signer, you print their name. There's room for 2 buyers, husband and wife. You got more buyers, you got a form. You notice there's nothing here about acknowledgement of receipt. Remember, there used to be a box here where the buyer signs, seller signs, sends it back, and the buyer's agent acknowledges receipt. Remember, you don't need that anymore because as soon as it's sent, it's delivered. You don't need to prove that they received it. Seller accepts it, same thing. If the seller's an entity, they're going to check the box, going to put the name of the person signing and the full name of the trust if you want to. There's something new here. It used to be on the old form, you could accept an offer subject to a counter offer. You can now also accept an offer subject to a backup offer addenda. Sellers don't have to take backups. Sellers don't have to look at backups. But if for some reason, in this market, you probably wouldn't, but if you want to, you can say, okay, I'm accepting your backup addendum. And the way you do that is by checking this box. Okay. By the way, does the seller has 3 choices, right? Accept, counter, or don't do anything, ignore it. Does the seller have to tell the buyer that they didn't accept or counter their offer? No. But to make the buyer happy, to make the buyer's agent happy, maybe it's a good idea as a listing agent to try to get the seller to initial this. Okay. All right. Then we get the very last page. I mentioned before, the new thing here is this part. Both agents are supposed to put their actual designated electronic delivery address. Usually that's an email. You're telling the other side, you want me send me something, send it here. This is the only place you can send things where I get it. But if you send it there, as soon as you send it, it's considered delivered. Buyer's agent, do you have to prove, do you have the right for proof that your offer was presented? Once you make an offer, after you make the offer, if you make a request, the seller's agent is required by the Code of Ethics in writing to tell you when they presented their offer, and they can do this on the blank at the very bottom. What if the seller ignores your request? They violated the Code of Ethics. You can file it, dispute the board. You can file a professional standards complaint, an ethics complaint at the Board of Realtors. They may have to pay thousands of dollars in fine. What if the listing agent says they presented to your offer, but they didn't really do it? If you can prove that, that's fraud where they lose their license. So it's very serious. All right. I just have one more question. Charlene, why would an assignee be used? Maybe the buyer, they're in escrow, all of a sudden they decide, I don't really want this house, but maybe my friend wants it. So I'll assign it to him. That's all. Or they're in escrow to buy it and their friend says, I love that house you're buying. How about I'll buy it from you? Well, you could close the deal and then sell it to them, or you could do a double escrow, or you could just assign it to them in the middle of the escrow. One other possibility is if you need a co-signer. You need to put someone else on title, maybe. That's an assignment which you can do in escrow. Okay, guys, I know that was a lot, but we're done. Unfortunately, I got another meeting. I'm going to do one thing. I'm going to put in the chat my email address to everybody, govh@car.org. And email me anytime you want. Hopefully I'll see some of you in Escondido on June 29th. If any of you are going to the CAR meetings next week, I'll see you there. Otherwise, it's been real. As Michelle Richardson says, it's not a deal unless both parties agree. Yes, that's what I said. All right. I'm done. Thanks, everybody. See you next time. Bye-bye.
Thanks, Gov.
Welcome. See you, Shirley. Gotta go.
All right.
Okay, bye-bye.